Well, the recent case the Labour Court dealt with was that of Unitrans Supply Chain Solutions and another versus Nampak and another. And in essence, what the case dealt with was the transfer of a part of a business to another service provider. And if I can just give you some context on what Section 197 is about. Section 197 of the Labour Relations Act deals with the transfer of a business as a going concern from an old employer to a new employer. What this provision aims to do is to facilitate the transfer of employees in the event of a transfer of a business as a going concern. Now, in the case of Unitrans Supply Chain Solutions, what happened is that Unitrans Supply Chain Solution had a contract with Nampak to provide warehouse services. And in performing those services, Unitrans Supply Chain Solutions utilized employees employed by a subsidiary company called Unitrans Household Goods Logistics. Now, the contract was between Unitrans Supply Chain Solutions, but the employees that were performing the service in terms of that contract were employed by a different entity. And in performing the service, another important aspect was that Unitrans Supply Chain Solutions used assets and equipment that was provided by Nampak. Now, Unitrans Supply Chain Solutions performed the service, and on expiry of that contract, a new service provider was appointed by Nampak to provide the service. Now, on termination of that contract, Unitrans Supply Chain Solutions approached Nampak and said, well, I believe that Section 197 of the LRA applies in these circumstances, and therefore the employees that perform the service should transfer with the business that has transferred to TMS. Now, TMS did not agree. It went to the Labour Court, and when it got to the Labour Court, he argued two main important points. The first point they spoke about was in relation to the business. They held that this was purely a termination of a service contract and that no business of Unitrans Supply Chain Solution had transferred to them as TMS. The second point that they argued before the court related to the employees. Now, if you recall, Section 197 talks about the transfer of a business as a going concern from the old employer to the new employer. So TMS said, well, you're not the old employer because these employees were not your employees. They were the employees of your subsidiary. Therefore, that provision does not kick in. Now, what the court held in these circumstances was that there had been a Section 197 transfer from Unitrans Supply Chain Solutions to TMS. And the reason for this was as follows. The first thing in relation to the business that transferred, the court held that the warehouse services constituted an economic entity. Now, what that means is that it constituted a business. Now, what kind of business? What did it comprise of? Was the important thing. The court said the contract forms part of that business. The contract to perform the warehouse service was one. The performance of the warehouse activities, so what was being done in the warehouse by Unitrans Supply Chain Solutions, the performance of the activities by the employees, and the right of use of assets. So those four elements constituted a business. And those are the things that are now vested in TMS, with the exclusion of the employees, which TMS had refused to take over because it held the stance that Section 197 did not apply in these circumstances. So the court said if the employees, then it would be a complete business. And this is the business that we would find at TMS. So that was the one point in relation to whether or not a business had been transferred as a going concern to TMS had taken place. Now, in dealing with the second issue in relation to the employees, there was an important factor that the court also looked at. The one was in relation to the relationship between Unitrans Supply Chain Solutions and Unitrans Household Goods Logistics. These companies had a close relationship because they belonged to the same group of companies. That was one thing the court noted. And another important thing the court spoke about was that it would be too much of a formalistic interpretation to hold that Unitrans Supply Chain Solution is not the old employer, purely because these employees were from a different entity. It said that would allow employers to have arrangements where in one company you have the contract that's performing the service, and in another company you have the employees. And you have this arrangement because then you want to argue that 197 does not apply because the old employer is not the one that is transferring the business. So the court said if we allowed this to happen, then it would have run the danger of people circumventing the section by having such arrangements. So the important thing the court said there is that the employees that transfer are employees that are assigned to the business that is transferring. So the employees do not have to be employed by the company that's transferring its business at the time. As long as they're assigned to that business that is transferring, that is an important aspect. So that's how the court dealt with those two important points. And going back to the first question you asked me about the right of use, a lot of jurisprudence was taken from European courts. So now this is the first time really that a South African court is being definitive about the issue of the right of use of assets and saying it doesn't have to be ownership that transfer, but a right of use of assets can transfer. This case is currently on appeal and we're waiting the outcome of that appeal.